We're going to start the meeting in 1 minute. Hello, everyone. Welcome to the January 29th, 2025 Low Providence Township Zoning Hearing Board meeting. I'd like to start the meeting with the Pledge of Allegiance, so please rise. Flag to the back. Pledge allegiance to the flag
of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, thank you. I'm going to do the roll call for our zoning hearing board. Gary Brown, here. Travis DeCaro, here. I'm Chris Gertis, and I'm here. Mark Kaburski, here. Joe Pucci, here. Rusty Raymer, here. And our solicitor, Eric Fry. Eric is here. So, Gary, can you read our statement, please?
The zoning hearing board will give all interested parties an opportunity to ask questions and testify in connection with the applications being heard tonight. After a witness for the applicant completes testimony, you will be given an opportunity to ask questions of that witness. In addition, after an applicant has completed its case, you will also be given an opportunity to testify, which will require you to be sworn as a witness. If you wish to participate in the hearing on an application, you should complete the entry of appearance form, which will be provided to you by the zoning officer, Mike, who's sitting in the front here. We ask your cooperation in maintaining silence during the hearing so that both the board and the court reporter can hear the testimony of the witness. We also ask that all cell phones be turned off.
Thank you, Gary. And Joe, can you read our case for this evening?
Okay, is that on? Case Z23-33, Resources for Human Development, Inc., 4700 Wexahicken Avenue, Suite 126, Philadelphia, PA 19144. The applicant is seeking to establish supportive short-term housing as a use on the grounds of an existing substance abuse treatment facility. Under 143-156A, the applicant is appealing the determination from the zoning officer denying the proposed use at this location. Under 143-161, applicant is also seeking an interpretation of the ordinance asserting supportive short-term housing is undefined by the ordinance. In the alternative, under 143-169C, applicant asserts a substantive validity challenge to the ordinance claiming total exclusion of supportive short-term housing together with any other relief deemed necessary or appropriate by the board. The parcel ID of the subject property is 43-00-03289-00-7. The subject property is located at the Eagleville Hospital, 100 Eagleville Road, Eagleville, PA 19403, and is in the R1 Residential INO Institutional Overlay District.
Thank you, Joe. Before we get started with the procedure, I just want to take a few moments to cover some of the logistics of the meeting and also how the meeting is going to flow tonight and any additional meetings we may need. So as you heard, we're asking everyone to please silence your cell phones. It's important that the court reporter, Tim, can hear the various testimonies and questions as he is going to be recording that for the public record. So I also ask that you maintain the appropriate decorum for the meeting, be respectful. Please don't clap, don't cheer, don't boo, that sort of thing. We do want to maintain the meeting flow. If Tim cannot hear the testimony, we're going to have to stop the meeting perhaps repeat whatever was testified, and it's just going to make things take longer, and we'll have to be here longer, which I'm sure everyone doesn't want to do. So once we get started here, the first thing we're going to do is we're going to establish party status for individuals and entities that are requesting that. Only parties will be able to ask questions during the evidence collection portion of the meeting, and only parties may present evidence. The next thing we're going to do is we're going to review several requested subpoenas and transcripts that we need to consider as a part of business. After that, we're going to establish the next 3 meetings scheduled. Actually, I'm going to do that now. We have a meeting scheduled for tomorrow evening at 7 o'clock here at Arcola Middle School. The next 2 meetings, should we need them, will be scheduled for February 24th and March 24th. Both will start at 7 p.m. Here at Arcola Middle School. The meetings need to end promptly at 10 p.m. The school district needs to get ready for the next day, and they've asked that we adhere to that hard stop time. We will take a approximately 5 or 10 minute bio break tonight at 8:30. So if you need to take a break at that time, do so, but please come back promptly. Okay, so then we're going to get into the business part of the meeting here. So we're going to then ask Eric, our solicitor. He will present exhibits that have already been provided to the township, and we're going to submit those into the record. After that, we're going to begin the evidence and witness process. And we're going to start with the applicant. The applicant will then call whatever witnesses they have chosen to testify. That witness will be sworn in. And then for parties that have been established, they will be able to ask any clarifying questions of that witness. We're going to go in order. We're going to follow this order throughout the presentation. After the applicant presents a witness, the township will be allowed to ask the first round of questions, followed by Streamlight, the neighborhood attorney, any other individual parties that have party status, and then the zoning hearing board and our solicitor. We will limit our questions in respect to the time that we've allocated for the meeting. If we have a clarifying question, we'll interrupt and ask that question. And then after the applicant has completed their witness process, then we will then begin to allow other witnesses to present. And we'll go in that same order, starting with the township, then Streamlight, the neighborhood attorney, and then any other parties that have been established. And again, that same questioning process will begin in order. The applicant will be able to ask questions, etc. So when that process is done, we're going to place all that testimony and questions on the record. We're going to close the hearing, and then at that time, we will allow any additional public comments or questions that may not have been already presented by the various witnesses. We will put a time limit on that when that takes place. We will be recording that. The court reporter will record that, but that will not be part of the record. And that will conclude the presentation and examination of witnesses in the comment portion of the meeting. At that time, Eric and I will ask the attorneys representing all the parties to provide draft findings of facts, conclusions of law, and written arguments for each of the parties. And then the zoning hearing board will consider all of the testimony, all of the records provided, and we'll use that and deliberate and reach a conclusion. And we'll be doing that separately. When we've reached a conclusion and we're ready to make a motion on the variances you've heard, we'll call another meeting and be able to do that. So I don't know when that's going to be at this point. You heard that we have 3 additional meetings scheduled. At the end of each meeting, we'll establish what's going to happen the next day or the next meeting, and we'll go from there. So with that, Eric, I'd like to turn it to you, unless I missed anything.
Very thorough. Thank you.
So we have a couple obvious parties here, so Mr. Jonas, why don't you stand up and put your name into the record, if you could.
Good evening, I'm Mark Jonas for RHD along with John McShay.
And who's here for the township?
Yes, on behalf of the township, which will be asserting its party status under section 9083 of the NPC, Gregory Mileniak from the Solicitor's Office.
All right, before we get into the other witnesses, or the other parties, I apologize, I want to put some board exhibits into the record. Just for everybody, B1 will be the application. B2 will be the legal notice for this evening. B3 will be the proof of publication for this evening. B4 will be the certificate of posting for the meeting this evening. And then B5 will be the certificate of notification, which includes the draft letter as well as the list of neighbors within 500 feet, as well as I believe there were a couple other residents who asked for that notice. There's 8 or 10 of those that are on that list as well. So that's all of that. And Streamlight, so Bagley, if you want to just enter your appearance.
Joseph Bagley for Streamlight Inc.
Mr. Jonas, any objection to Streamlight or the township being a party?
No.
No objection to the township.
Thank you. That was my next question. And Mr. Yanoff.
Good evening, Michael Yanoff here for the Concerned Citizens of Lower Providence, the people listed in the list that I previously provided who are requesting standing for this evening's hearing. Thank you.
So, Mr. Yanoff, you provided a list of roughly 1,211 people.
Roughly, yes.
Okay. Mr. Jonas, any objection?
Yes.
What's your objection?
Objection is to a lack of standing of 1,200, and we'd like to get confirmation that these 1,200 are actually clients of Mr. Yanoff, for whom he has provided an engagement letter, as opposed to simply a petition for everybody who simply doesn't like supported housing.
Mr. Yanoff?
It's really not my requirement to get us an individual letter of engagement from each of the 1,200, especially if we're seeking derivative standing under the case law for the Concerned Citizens of Lower Providence. All of the individuals listed in those lists are members of the Concerned Citizens of Lower Providence, and the law would allow that entity to have derivative standing. Notwithstanding that fact, there is a list which I have provided, which Mr. Fry, you and I have reviewed, of approximately 15 individuals who all live within 500 feet of the subject property and who would have standing on that basis under the case law by itself. So I would not be, I've never been in a situation where I've been required to receive 1,200 letters of engagement in that kind of situation.
All right, so just for the public's purposes, Mr. Yanoff did provide this list of 1,200 people. I cross-referenced that list with the list of individuals that received the township's notice that if they were within 500 feet, and Mr. Yanoff's correct that 15 people are on both lists, Mr. Yanoff's list and the township's list. While I tend to agree with you, and I think the board agrees with you, that those 15 people have a right to be a party here, and if you represent them, then you would have standing to appear here. I don't think the board's prepared to accept the entry of concerned citizens when it's not a formalized group. Further, I found at least one person that's on your list that you don't represent. So it's a little hard for us to sit here and take a representation that you represent 1,200 people when I know there's at least one example, and I spoke to that person immediately before the hearing starting tonight, that you do not represent her.
I'm not going to pretend that I'm going to force the board to listen to 1,200 people saying I represent them. I'm content to indicate that of the 14 or 15 that I represent, that they be granted standing. But I would disagree with you, Mr. Fry, with respect to the derivative standing issue. I think the case law is pretty clear that an organization, a nonprofit or any kind of organization, and it doesn't necessarily have to have any degree of formality to it, but that organization, if it has a direct and substantial interest, and it does in representing the people who live in proximity to this project, would have derivative standing. So I would push back on that particular portion of it, but I am content to indicate to the board that there are at least 14 or 15 people who have standing and would be accepted by this board, should be accepted by this board as having standing in this proceeding.
All right, so let's deal with Mr. Jonas's request. So do you have any of those 15 people here that will stand up and state that you are their attorney?
He's my attorney.
He's my attorney.
So, individuals, as you heard the rules, go ahead, sit down. We'll have you come on. We can't have you interrupting. We can't have screaming from the audience. Okay, we have a court reporter.
Hold on a second. We're running the meetings, not your council, so, and please be quiet for 1 second, Mr. Young. Please be quiet and be respectful, and we'll get through this, okay? Thank you.
So if you want to go over, stand next to Michael and Mr. Yanoff, he can introduce you and you can state that you're his attorney.
Mr. Chairman, I don't want to represent that I'm running the meeting, just so I understand that.
It was more to the general public that we're
Thank
trying to
you.
keep control. We knew this was going to be an issue, so.
I ask that these individuals be allowed to identify themselves and their address for the record.
Mr. Yanoff does represent me. My name is Damian Kuzi. I live at 3247 Maryland Avenue.
Hello, Mr. Yanoff represents me.
Keith goes.
I'm gonna have to ask each one, yeah, you say what you spell.
Mr. Kuzi, if you could come back.
Damian Kuzi, Kusy.
As I mentioned, Mr. Yanoff represents me as my attorney, and it's Bob Doran, D-O-R-A-N, 1001 Michael Lane, Eagleville, 1943.
Mr. Hanoff represents me. My name is Lisa Doran, D-O-R-A-N. My address is 1001 Michael Lane, Eagleville, PA, 19403.
Hello, my name is Gabby Van Leer, V-A-N-L-E-E-R. I live at 1110 Wooded Place, and Mr. Yanoff represents me. I do also have a quick question. My husband is going to be here at 7:30. He's also represented by Mr. Yanoff and would like to be a part of this, so can I do that for him? Or?
So Kyle Van Leer, your husband?
Yes.
Okay, thank you.
Mr. Fry, can we clarify this? Is that person standing up, the persons on that list who are within 500 feet, or are they anyone in that 1,200 list?
These are people that are on both lists. So far, everyone who has stated their name are on both lists. So I will stop them if I don't find them on the list, and I'll let you know.
Thank you.
Okay.
And I'm good. I'm good.
Yes, thank you.
Mr. Yanoff does represent himself, Melissa Mancini, M-A-N-C-I-N-I. I live at 1003 Michael Lane.
Hang on a second. I don't know that I have you on receiving a letter from the township. Were you within 500 feet and received a letter from the township?
I've been with 500, but have not received a letter from the township.
What was your address again?
1003 Michael Lane.
Mr. Yanoff represents both myself and my husband, Luciana Bove, Luciana Bove, 1002 Michael Lane, and Paul Bove.
Mr. Yanoff represents my husband and myself, Rachel Beatty and Rob Beatty, Rachel Beattie, 1005 Michael Lane, Eagleville, 194.
Carol Loney, 97 South Grange Avenue, Keirmaloney. I have a question for you. So on that list, it only said Maloney 1. My wife, we both signed the paper to be on this, and Michael Yanoff represents both of us, so.
Jennifer Maloney, 97 South Grange Avenue.
You already got it?
Yeah, it's my wife.
Give me a second.
All right.
I don't think 97 South Grange was within 500 feet.
And we were in the 15, last time, I'm not gonna hold the meeting up, but we were in the group of 15.
Oh. So you requested to be mailed that, okay, so.
Right, we've been getting that stuff the whole time.
So we're gonna hold you aside, Mr. Jonas, he was not somebody within 500 feet.
We object.
Okay.
Good evening, my name is Brian Keating. I live in the Eagleville section of the township. I live on Circle Drive. And I have standing because I filled a paper.
Sir, we're not doing individual, we're just doing if you represent, if Mr. Yanoff represents you.
I'm on the list. So Brian Keating, Eagleville. I'm sorry, Keating, and Brian is with an I.
I don't have you with being within 500 feet either.
I'm not within 500 feet, but I qualified as standing at a previous meeting.
Understood.
Without
Mr. Jonas?
objection
Objection.
at the time.
Understood.
My name is William Bailey, 3431 Teresa Street. William Bailey, 3431 Teresa Street, Eagleville, PA. Michael Yanoff represents me. Bailey.
Were you within 500 feet?
I'm pretty sure. I didn't quite measure it.
Did you receive notice from the township?
I'm not sure.
You're not on my list as being on both.
I've been to every meeting we had.
That's understood.
Objection.
Joe Venezia, I live at 3361 Amelia Street, Eagleville, PA. I could throw a softball and hit the addition they just put on that building. Venezia.
Did you receive notice from the township?
Huh?
Did you receive notice from the township?
Yes. I guess I'm not on that too.
What was your address again?
Excuse me?
What was your address?
3361 Amelia Street.
Of the check case, Mr. Jones. Still looking for the township's list.
You gonna call 1,200 people up here?
Mr. Fry, the list I have shows 3361 Amelia Street, Joseph Venezia on that list,
On the township list?
on the township list.
If you object to him?
Not if he's on the township list, no.
Hello,
Hello, Mr. Yanoff represents me. My name is Colleen, 2 L's, 2 E's. Last name is Banas, B-A-N-A-S. I live at 4090 Eagleville Road, Eagleville, Pennsylvania, 19403. And I've received 2 letters.
If I may. My name is Joe Rittenhouse. I live at 309 Conestoga Way. I received a letter through the Eagleville Trust. It was at 30, sorry, I'm looking at the correct. The Eagleville Trust, who also received a letter for all the people in that building, as well as representing Jackie Rittenhouse at 3360 Visitation Road, who also received that letter. Yes, they own the Eagle Stream apartment complex, right? I think a good chunk of people might also qualify, who are on the list that you gave, the 15.
So portions of that.
Correct. Definitely, like I said, throw a softball, could hit it.
Understood. Mr. Rittenhouse, so just explain your standing to me again?
Yep. I live at 309 Conestoga Way, apartment E51. It is directly across from multiple people who live on this list, within 500 feet. And then the secondary one that was also not on the list that you sent to Michael Yanoff, our attorney, but on the list that you sent out letters to was to 3360 Visitation Road, Collegeville, Pennsylvania, for Jackie Rittenhouse, my mother.
Mr. Fry, that is on the township list.
Okay.
Thank you.
No objection then?
No.
Okay. So you have a number, is that all, Mr. Yanoff? So, I did not see that 103 Michael Lane, so they,
Mancini, is that who you're talking? 1003.
yes. Did not see that on the township's list. You see that, Mr. Yanoff?
You're not seeing the list.
I see 1001 and 1005, but not 1003, so it's probably just out of that 500 feet. So what I would suggest to the board is that we give the party the status to the individuals that were within 500 feet. There were a number that weren't, and I'll get their names more clear from Tim off the record here. But I think for the individuals that were within 500 feet, I suggest you accept those as parties, not the group as a whole, and not for the individuals that weren't within 500 feet.
Mr. Fry, if I may suggest something before the board votes on that.
Yeah.
If Mr. Rittenhouse is correct, and the notice was actually sent to the owner of Eagle Stream Apartments, and we should verify, not at this hearing, perhaps before tomorrow night, which residents in that building, in that apartment house, would qualify based on the notice that was sent to the apartment owner. And you may find that the list is much greater than it. Not that we need to do that in order to move forward, but I think it would be appropriate to list those people as well.
I would think it's appropriate too, and then obviously subject to the objections and cross-examination by Mr. Jonas at that time. But I think you're absolutely right. You have standing to participate. You have enough clients listed here that testified on record that you are their attorney, so you'll be able to participate for those individuals, not for the couple that we identified are off the list and too far away, but you will be allowed to participate as an attorney for those individuals.
Thank you.
And if you have more evidence you want to present to have additional individuals, I don't think you need it, because you're going to be involved and you can represent them without them being parties, but if they really want to be a party, feel free to present that evidence when you have it.
And I'd also like to present an argument on the derivative standing of the organization. But again, I don't want to hold up the proceedings this evening. We can hold that.
I appreciate that.
Thank you.
So we're not going to make a motion on that. We're give standing the way I just stated. So
I'm okay with that. Thank you.
thank you. And, okay, so now I'll wait for everyone to sit down. Thank you all for your cooperation, Pat. I appreciate it. While we're waiting for them to sit down, are there any individuals who have additional attorneys, any other attorneys in the audience Any individuals that want to become a party for party status without an attorney. And again, what this does, you can make your way up to the podium if you want, so I see one hand. This just allows you to ask questions and be involved during the presentation of evidence. Everyone's going to have an opportunity to make a statement for or against this application when we're done with all the hearing process. So, go ahead.
I wanted to gain party status.
So name and address, please.
Allison Piekarski, P-I-E-K-A-R-S-K-I, 525 Highgate Road, Eagleville, PA, 19403.
Are you within 500 feet?
I am not.
Mr. Jonas, do you object?
Yes.
So what you're, based upon that objection, what we're gonna ask you to do is tell the board and the applicant why you're different than just the general public. How is this gonna impact you differently than the general public?
It'll probably impact us all the same. However, if you were to go, instead of going by car as you're stating, if you go through the fairgrounds, you come to my backyard. So I am not as far as what your gentleman might think that I am. Anybody that's actually in that development has the same as me. I lived here all my life. I used to walk to get to that fairground. It's much closer than you think. You go through the yard, you're right there. So the impact is there.
Mr. Jones, you still object?
Yes.
So it is up to the board, but the standard we're looking at is that she's got to be impacted somehow differently than the general public. I didn't hear that. All right, we're going to uphold the objection and not allow you to become a party. Again, you'll be allowed to make a statement at the end of the proceedings. You just can't ask questions during the process. You can't present evidence, okay?
Good evening. My name is Sal DeRosa, D-I-R-O-S-A. I live at 2002 Bayless Place, Eagleville, and I am within 500 feet.
He's on the list, Mr. Chairman.
He is on the list. I see one, so Salvador.
Salvatore.
He
Or
is-
Sal.
So he is within 500 feet, Mr. Jones. Any objection?
No.
Okay, you're a party, Mr.
Thank you.
Mr.
DeRosa.
DeRosa, thank you. Thank you.
I'm Kathy Eske, and I'm a resident of Little Providence Township. And I have a statement, the zoning hearing board has...
Ms. Eske, if I could just have your address first.
540 Highgate Road.
And you're not within 500 feet.
Correct.
So I presume your statement's going to make arguments for Mr. Jones's objection, which he's about ready to make.
Yes, if he would allow me to finish this time. The zoning hearing board has the right and the authority to extend the 500-foot area. I strongly suggest that you do so. Include everyone in Lower Providence Township only, not to others from different areas or townships, until the end of the hearing where they can make their comments. I understand when you make this request, it sometimes requires that you give case study to give evidence as to show cause to have this extension granted. I'm not a lawyer. I do not have the financial means, nor do I have access to this type of research. Therefore, as a 60-year resident of Lower Providence Township, I'm asking you to convene for a few minutes, review my request, as an outcome of this hearing will have a profound effect on the entire township and its residents. There may be an objection, but I do believe the zoning hearing board can approve this and is in the community's best interest. I thank you.
Mr. Jones, she's not within 500 feet. Do you object to her being a party?
Mr. Frye, based on the standard that the board has already set and applied to other requests for party status, based on statements by Ms. Eske, based on the distance of her house to the property, which we believe to be over a mile, we asked the board to take additional notice. There's no basis to allow her to participate, and we object.
We sustain the objection. You will not be recognized as a party.
I understand that, and I accept that. However, this is a community thing. I did not ask him to accept me. I asked him to give all the residents of the township, and the board does have the authority to do so.
We're asking to refrain from the clapping again. It just prolongs things. And Ms. Eske, you will be allowed to make a comment at the end. So
I realize that, but if I have no standing and I make comments, they do not necessarily come into the equation of making decisions. They're just comments. But then I have no opportunity to ask any questions.
that's correct.
Very good.
I'm sitting, my name's Joe Venezia, you have me on record. I live on Amelia Street. I wholeheartedly agree with this woman. Limiting the feedback to 500 feet is out of control. Anybody within this township should be allowed to speak.
What was your name again?
Joe Venezia. Anybody in this township should be allowed to
Mr.
speak,
Venezia,
not limit them.
Mr. Venezia, you have to let us run the meeting here. Are you asking to become a party?
You already
Yes, for you. All right, I asked that you, your attorney has to speak for you, so we ask that you sit down. Thank you.
Kelly Gates, Kelli, Gates, Gates, 4037 Carden Place. I was put on the record at previous meetings, and Mr. Yanoff represents me as a party as well. I wasn't part of the first group, but I know I was put on the list.
I'm sorry, can you state your address again, please?
4037 Carden.
I didn't hear the street name.
Carden, Cardin.
Thank you.
I know I signed the paperwork and such at previous meetings. I think I was kind of put near the end, but I just wanted to state that Mr. Yanoff.
I did not see, there are many addresses on Carden that are within 500 feet. Yours is not one of them. And just for the public, this is a different board. You may have spoken before at a township meeting and received party status.
No, I have showed up at 2 previous because since I signed the paperwork back, I believe, a couple meetings last year with the zoning board, I was then now receiving the letters about the meetings going forward.
So you're not within 500 feet. How does this impact you differently than the public?
I might be 800 feet. I live right across the street, and the prison, the hospital, everything is literally right there along Eagleville Road.
All right, getting back, okay, how does this impact you differently than the public?
I just wanted to put on record, Mr. Yarnoff, I'm part of the party with Mr. Yarnoff, but I wasn't within the first group because I'm not within the 500 feet, but I am put on record on the mailing list of everything else from the last couple meetings from last year. And I did get the last 2 mailings for this meeting as well. To just create a standing party, however you want to
You
put it.
can receive those letters, but we're not going to recognize you as party status.
Okay.
Kieran Maloney, 97 South Range Avenue. I wasn't going to waste anybody's time, but this dude's been wasting our time for a year. I want to become party status, and this is going to affect me. So the back of the prison is where my house is. There's people that walk from the rehab up and down the road. So, what reason? I'm a taxpayer. This dude came in here disrespecting this township, calling us lucky and spoiled, and I'm gonna be honest, I feel really discriminated against. For some reason, it's a penalty. I'm stating my case.
The board has already rejected his request for standing.
No, that was with a lawyer. This is for standing.
We objected to there, but you're not within 500 feet, so unless you're
So he can't represent me, that's fine. I'm not in the lawsuit. But I'm a taxpayer and this is gonna affect everyone in the township.
He's on the list.
Everyone in the township. It's wrong. It's wrong. Because we're gonna listen to pastors here, we're gonna listen to people tonight that are
Okay, sir,
in the township.
I'm going to ask that we suspend this discussion. Right now, we're looking to establish party status. We're not taking comments or testimony. Next person, please.
I'm just curious if we cannot maintain, if we're not, if you don't.
What's your name and address,
Patty
please?
Taylor, 3987 Yerkes Road, Collegeville, Lower Providence Township. I'm a township resident, and I want to know so if you don't grant us party status, what does that mean? We have no say, what we say doesn't matter, has no standing, what does that mean? Please explain that to me.
It's what was explained at the beginning, is that you will not participate. As witnesses are presented, you can't ask them questions. After the witnesses are done, you can't present evidence, but you will be allowed to speak at the end and give your opinion for or against the application.
Okay, but you guys you represent all of us in the township, not just within 500 feet of any particular space, but you guys have the ability to make us, to expand that circle, that area? Is that what I understand?
Yes. Yes,
The
is the answer.
standard is that
Yes is the answer.
Is that
yes is the
you
answer.
have to tell us how you're impacted. So there is a standard here. If you're within 500 feet.
The question, it was yes, you have the power.
Individuals, you have to be quiet, please. Other than that, the parties have a right to object to you. They're objecting to you, okay? If they're not within that 500 feet. So then you need to tell us how this impacts you differently. If you can't do that, we're going to sustain the objection. So far, no one's been able to do that.
Of course.
There might be a situation where you're impacted differently.
Right. Is the assertion, though, that this project, I would argue that this project is different than, if somebody wants to encroach on the 20-foot side yard setback, right? I would argue that impacts us much differently than just within 500 feet, because these people can walk way more than 500 feet, right? So I would argue that.
Objection sustained. You're not recognized as a party. Next person, please.
Okay, my name's Sharon Weinhold. I don't live within the 500
Sorry.
feet.
Slow down.
Come closer to the mic and give us
I
your
live
name.
at 3508 Ridge
Name
Pike,
first.
Sharon Weinhold. And I am
Spell your
impacted
name.
already because there's
Spell
people
your name.
roaming the streets.
Ma'am, spell your name for the court reporter.
SAJRONWENHOLD.
And now your address, please.
3508 Ridge Pike.
Now,
I've had people try to break in my house several times. I've had the police there, and all I hear is, it's just drunks roaming around. Well, I'm tired of people roaming around our neighborhood that don't belong there.
Okay, so I want to pause the meeting for a minute. So this is a procedural process that we're stepping through to establish folks who are in party status. So I'd ask that you be respectful of that process, and we're enabling the various legal representatives here to object or allow you to represent, to be participating as a party in this hearing. If you continue to disrupt the meeting, we're going to pause the meeting. Okay, this applies to everyone here. We're going to pause the meeting, take a break, and come back. And we'll continue to do that until you orderly follow the process here. So.
Well, obviously, you don't care.
What's your name?
My name is Lisa Wenhold, I'm her daughter, and I
Okay.
also live in the township, but I'm a little further out. But the reason she is also directly impacted is because she's had people directly from the prison peeping in her windows. She's directly had people from the grounds on her property rearranging her stuff, leaving their Nike slides in her driveway. She's scared. She's a senior. She lives alone. She's on the backside of the prison, and she has people from the prison on her property. They stole my dog at one point. It's a problem. And it's a little bit more than the 500 feet that you want to admit to, but she is very directly impacted when she's scared to be in her own home. And she may not be the best at verbalizing it, but she's impacted, and there's police reports, several of them. The one officer in your lobby was out at her house a few months ago over somebody from the grounds trying to get in or do God knows what. She's had people knocking on her door asking to come inside. She's very impacted.
Thank you. This is not the time where we're accepting comments or testimony. Okay, so we're establishing those folks who have party status. So, sir, please, your name?
Damien Kuzi, 3247 Maryland Avenue. I want to address you guys on this 500 feet nonsense. Are you going to stop taxing people at 500 feet that are going to pay for this shit? Because we're all fucking paying for it. You want to shut people down and you want to tell people to be quiet, let us talk, because you're taking our voice. We pay your check.
We're going to pause the meeting. Okay?
Pause the meeting. I don't care. I'll hold this shit up all fucking night, all week long.
Yeah.
Okay, the meeting's back in session, and we're going to continue establishing folks with party status.
My name is Jeff Turner, J-E-F-F-T-U-R-N-E-R. I live at 64 Eagleville Road. No one lives closer than I do. And I just had a curious question. Are any of you in the 500 feet?
We are not.
At this point, I'm not with any other group. I did just receive the mail for this meeting.
So you're saying you are within 500 feet?
I'm across the street.
He's on the list, Mr. Fry.
Thank you. Any objection, Mr. Jones?
No.
You are a party, Mr. Chairman.
Hello, Kyle Van Neer, 1110 Wooded Place. My wife came up, or I missed the first part of the meeting, and my wife said she came up and confirmed that I was on the list. Just wanted to confirm also.
Kyle? Is that what you said?
Kyle Van Neer.
Yeah, so you were, I believe, represented by Mr. Yanoff, correct?
Also, yes.
Okay, you're already a party through Mr. Yanoff.
Individually?
No, so if you're represented by an attorney has to speak for you, so you have to go through your attorney, and that's who will ask questions and participate in this for you.
Okay, so I can't make an individual speech or individual statement?
At the end you can, but not during the hearing.
Okay, unless I'm requested by the lawyer to do so.
I didn't hear what you said.
Unless I'm requested by the lawyer to speak, or if I...
But he can call you as a witness, correct?
Okay.
Kelly Gates, K-E-L-L-I-G-A-T-E-S, 4037 Carden Place. So even though I didn't give a notice, we are an HOA of 260-some townhomes. We pay dues that take care of the ground, blacktop,
Mr. Fry.
sidewalk,
She was already requesting party status and was denied, I believe.
but I have something that I'm going in because we pay for the grounds for
Objection.
kept in that area.
Okay, came in. So your position is your townhome is not within 500 feet, but your townhome has common area that's controlled by an HOA?
That I technically
Right,
own
that-
because
that's-
I pay dues.
I understand, but are you a member of the HOA, a president, or a?
I'm a homeowner.
Okay,
I'm a
you're not an
homeowner.
officer of the HOA, so you can't, there's no vote of the HOA to be a party here this evening, correct?
I'm a homeowner.
Ma'am, please answer my question. Was there a vote at the HOA to become a party?
No,
So I'm gonna suggest to you, you go back to your HOA, you You ask them to show up to get party status, and the HOA can get party status for you.
Why? I'm saying there's a homeowner
I
and trying
understand.
to get party status because my dues pay for all the grants. It's not
And-
just pays just part.
Ma'am, you can say it 3 more times. The decision still will be the same. Go back to your HOA, have them vote to become a party status. Their land is, you're telling me that HOA land is within 500 feet.
A lot of it, yes.
All right, so
Yes. But
just
it's
go back
not
to the
just
HOA and have the
Vegas, it's
HOA
all
enter
over.
Excel. Okay, thank you. All right, that's everybody. All right, so we have the parties established. We will create a list of those for future hearings. There are a couple other procedural issues that we have before us. I think I'm going to deal with the easiest one first, and that is the transcript of the hearing before the township from April 4th, 2024 was offered into the record. Is there any objection to that being placed in the record? All right. Mr. Jonas, was that your exhibit or the township's exhibit, or how do you want to mark that? So,
Either way, Mr. Fry, it can be our exhibit or the,
okay. So why don't we, I just don't want to mess up anything you have ready for this evening, so why don't we just call that T1, since it's a township transcript?
Mr. Fry, I think it was Mr. Jonas's request to submit it, so I believe it should be his exhibit, not the township's.
Okay. So
That's fine.
I'm trying to be, just because we
That's
mark it,
fine.
so we'll mark it, A1 is fine, Mr. Jones, do you do not have anything pre-marked?
yeah, we do not, Mr. Fry.
Okay, so we'll call that A1. The second issue is there was a subpoena requested for the township manager to appear to both present documents and be a witness for the applicant. Is there an objection to that subpoena?
There is.
All right, we hear your objection.
Yes, there is no purpose for the township manager to appear before the zoning hearing board. The request in the subpoena was for the township manager to appear for the purposes of introducing the transcript of the April 4th, 2024 text amendment hearing, which has now been submitted to the board without objection. That renders this subpoena moot. And based on the contents of the transcript as well, the township manager has nothing else substantive to add to testimony to further the admittance of that transcript that's already been accepted.
Mr. Jones, is your subpoena, do you still request the subpoena? Do you?
Yes, because there are questions we want to ask about what transpired the night for which we now have the transcript. And the manager is certainly one of the persons who would answer those questions.
But the document speaks for itself. It is fully there on the paper. That's the purpose of having a transcript, that all that transpired in the public, before the public, many people who are in this room tonight and are parties to this proceeding witnessed and are on the record there. It speaks for itself, and the board can divine what it needs to from the text of the transcript itself without the manager appearing.
Mr. Fry, we had suggested to the board, to the township, that this matter be split, bifurcated into the appeal, separated from the validity challenge. The township solicitor said they were not agreeable to that. So this is far more than an appeal of a determination by the zoning officer. It's a validity challenge. And what the transcript will reveal is that there were discussions and drafting of ordinances and another agreement that were done by the township solicitor at the direction of the township. And then there was a colloquy during the April 4th hearing relating to the very substance of the zoning ordinance. And that's why this is more than just what the transcript says. There are a lot of background circumstances and whatever the solicitor was doing in terms of drafting an ordinance and then drafting a municipal services agreement, that became part of a public colloquy. And it is certainly the test for the issuance of subpoena is whether it's relevant. And because we have a validity challenge that is actually revealed in that April 4th transcript, we think having the manager, and we have another outstanding request, testify about those background circumstances relating to supportive housing, what happened on April 4th, why the ordinance is suspect, why all of that is relevant.
In Mr. Jonas's own words, he states the transcript will reveal what transpired at the text amendment hearing. And that is absolutely true. The purpose of the transcript is to reveal in perpetuity what transpired at the text amendment hearing. Anything that can be divined beyond that is beyond the transcript and is not relevant. Furthermore, the insinuation that the fact that there was an ordinance amendment drafted and a text amendment hearing held reveals that there's a purpose or validity behind the validity challenge has been disputed by case law. And I can share that case law with the board that says just because there was a separate proceeding before the governing body of the board does not mean that the validity challenge is valid and should be recognized by the zoning hearing board. So if there's other questions about the drafting of a text amendment, and that's the purpose of the applicant calling the township manager, it is irrelevant to these proceedings because the validity challenge that is brought has to be on the four corners of the challenge they're bringing in the ordinance in effect at the time, not the fact that the board of supervisors held a separate proceeding that is completely independent from the validity challenge to consider a legislative action.
Thank you. Mr. Bagley or Mr. Yanoff, do either of you want to take a position with this? I didn't think that's you. Any other party want to address the issues with the subpoena? It would be my recommendation to the board that there is potential evidence that you could get out of the manager with regard to this case, so this subpoena should be issued. Any objection to that? So we will issue that subpoena for the township manager. The next subpoena is for the township solicitor. I presume
there is an objection.
To that, a specific individual from your office, Michael Clark, specifically. So what's the objection to that subpoena?
Similar to the objection, the subpoena that was requested from the zoning hearing board chairman is specific to introduce the transcript. Now that the board has voted to issue a transcript for the manager, we would submit that calling the solicitor as well to testify to the transcript is duplicative and also moot, renders the subpoena request moot. Furthermore, if the request from the applicant is to question the township solicitor on the legal advice he provided to the township on the drafting of a text amendment, a municipal service agreement, or any advice on township policy or otherwise, certainly would not be relevant, would be privileged, and it would certainly be a waste of time in the zoning hearing board to call the solicitor for those purposes.
Mr. Jones?
Mr. Fry, the zoning board is the ultimate determinant of what is relevant and what is germane to the challenge. This is a very unique case because the solicitor spent months drafting an ordinance that addressed the validity of the current zoning ordinance, asked questions, gave answers. At that hearing, you probably will have never seen a matter where the validity of an ordinance followed a colloquy at a public hearing between the solicitor, making statements related to provisions of the ordinance, the reasons for the ordinance. They were in public and they are relevant to the validity challenge. We think the board should hear the testimony. If the solicitor had not been on the record at a public hearing, we wouldn't make the request, but he was an active player in the drafting of the ordinance in a separate municipal services agreement, making statements in public. We'd like to ask him why, what was the reason for that without breaking the privilege.
The why is the irrelevant part here. If a member of the board of supervisors is asking the solicitor a question at the meeting, the solicitor is going to answer within the confines of what he can respond to in that public setting. The why is not for the solicitor. The why is for the person asking the question. I'm not inviting Mr. Jonas to subpoena anybody else, obviously, but the colloquy he continues to reference is in the accepted transcript already. If the manager is going to attend and testify as to the transcript and the colloquy, which is the same basis that Mr. Jonas requested for the last subpoena, then anything to be divined from a layperson at that hearing who is participating can be testified to by the township manager in that proceeding. If there's any communications that are being sought from the solicitor for why he was requested to respond to questions, would also be a privilege, and again, a waste of time of this board's time. And for the sake of brevity, I would also incorporate all of my argument from the township manager's subpoena, because I think it is just as relevant to this, but even more so.
I appreciate that. Mr. Yanoff and Mr. Wagner, want to take any position on this one? No. Any other party want to take a position on this subpoena? My recommendation to the board on this one is that we do not make a decision at this point, that we review the transcript, take in the argument, potentially hear what the manager has to say during that testimony, and decide at that point in time whether we want to issue the subpoena for Michael Clark. Put that one on pause for right now, okay? So it's not a no, not a yes. I think, were there any other procedural things to get through? I think with that,
I would just ask the board, since the subpoenas are only being issued tonight, that the manager would give advance notice to accommodate the schedule of the board, and that he scheduled for a future hearing, not one tonight or tomorrow.
let's wait to see how far we get. We may potentially talk about that on tomorrow today with everybody. Okay?
We're pleased to coordinate the availability of the manager with the township solicitor.
Excuse me?
We're pleased to coordinate the availability of the township manager with the township solicitor.
Thank you.
Both.
We'll talk essentially.
Perfect.
That's when EJ will testify.
You got it. That's perfect. Thank you. The acoustics are bad. I think it's designed so you hear us, but we don't hear you. So it is a little difficult for us, so I apologize. With that, Mr. Jonas, we can proceed with your introduction to the case. If any other party wants to do an introduction now or hold them until it's their part of the case, what I would suggest. Okay. Mr. Jonas, you can proceed with your case.
Mr. Fryer, if it's okay with you, I'd like to proceed by calling our first witness.
Okay.
I'd like to call Mike Mazinski as a cross-examination.
We'll get Mr. Mazinski sworn in.
Sir, do you solemnly swear the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God?
I attest.
Would you state your name, please, for the report?
Michael Rosinski, M-R-O-Z-I-N-S-K-I.
Thank you, sir. Counsel.
Mr. Mazinski, you and I have met previously at meetings at the township, is that correct?
Yes, sir.
Do you mind if I call you Mike?
That is fine.
Mike, what's your position in Lower Providence Township?
I am the Director of Community Development and the zoning officer.
And can you give us just a broad scope of what your responsibilities are in those positions?
I am the head of the department that deals with the planning, the zoning, the building code, and the code enforcement task of the township.
How long have you served in those positions?
In Lower Providence, about 10 and a half years.
And what did you do before that?
I've, in various forms, I taught, I was in the private sector in construction, and I worked in a different, same role in a different municipality.
And what did you teach?
High school social studies.
Is it part of your responsibility to prepare and issue zoning determinations?
Yes, sir.
And in general, what's the procedure for you to issue a determination?
Once the written documentation is laid before me, I do review it and basically check it against the location so we understand what the zoning district is, and then basically open up the ordinance, the zoning ordinance, and try to match up the request to what's in the ordinance.
You make determinations upon request of a property owner or landowner, is that correct?
That's correct.
And when you issue a determination in general, do you draft them or does somebody draft them for you?
Generally speaking, I would draft them.
But there were exceptions to that?
There is sometimes consultation.
And with whom would you consult?
Other members of my department and with the township solicitor.
Is it party responsibility to provide, as part of determinations or in other contexts, interpretations of the zoning ordinance?
I am legally obligated to follow the ordinance as literally as possible. That said, I mean, there are probably instances of some sort of interpretation. Let's leave it as that.
Are you familiar, in a general sense, not word for word, with the Pennsylvania Municipalities Planning Code?
I am.
Are you familiar with the provision in the planning code that says essentially that if there's any doubt in the interpretation of the ordinance, that the benefit of that doubt goes to the landowner?
I am, with the proviso that there are opportunities for it to come before this board for interpretation.
As an appeal of your determination, correct?
Or, yes, either an appeal or a clarification.
And in fact, one of your determinations is part of the appeal by RHD that's now before the zoning board, correct?
I believe that's correct.
Are you familiar with the proposed supportive housing use of resources for human development?
Yes, to the degree that it's been described to me.
What's your understanding of that proposed use?
That it is basically a housing situation, a residential housing situation for those who may not have had it in the past, who are coming out of a situation of not having housing.
And where was it proposed to be located?
Initially, it was proposed to be located on South Trooper Road.
And then you moved to a different location, is that correct?
That's correct.
And what location was that?
Eagleville Hospital, 100 Eagleville Road.
Essentially, the supportive housing use is a residential use, correct?
It has a residential component to it, though it is obviously qualified by some differences.
What are those differences to your understanding?
That it is primarily a transitory housing provision.
And do you know what other services are offered for the residents at the supportive housing facility?
Only from the discussion at previous hearings.
And what's your understanding of it?
There is some education in terms of budgeting. There is some provision to allow individuals to interview for housing to find resources that may be out in the wider community.
Are you familiar with the zip code 19403?
I am.
What does that zip code include?
It includes mostly the eastern and southern sections of Lower Providence Township, along with a little bit of other adjacent municipalities.
If I told you that in 2024 there were approximately 100 persons who were homeless in that zip code, is that a fact that you're aware of?
I am not aware of that fact.
Let's talk about Eagleville Hospital. That's where the proposed supportive housing facility was intended, correct?
That is the second application, yes.
What's your understanding of Eagleville Hospital?
That it basically deals with substance abuse conditions, treatment.
How big is the property?
I couldn't speak to that.
Do you know how many buildings are on the campus?
Not directly, no.
Is the campus enclosed with any security fencing, anything like that?
There is perimeter fencing.
And are there security gates as well?
Yes.
Have you ever been within the grounds of Eagleville Hospital?
I have.
Are you familiar with any particular permits or approvals that the township has given Eagleville Hospital in the past?
Nothing directly, because the majority of what has happened at Eagleville Hospital happened prior to my coming here.
And that was what year, please?
2014.
Do you have a copy of the zoning ordinance with you?
I have portions of it.
Do you have section 143-205A in front of you, and perhaps your solicitor can lend you his?
I have it.
Would you read, this is within the institutional overlay district, is that correct?
That's correct.
And am I correct that the zoning of Eagleville Hospital is R1 residential with the institutional overlay district, INO, on top of it, correct?
That's correct.
And why don't you just explain for the record, what's an overlay district? What does that mean?
An overlay district, to my understanding, is giving specific qualifications over and above the underlying or broader zoning district.
So by directing your attention to section 143-205A, that is the legislative intent of the INO institutional overlay district, correct?
Yes.
Read 143-205A, the intent of the institutional overlay district.
Provide suitable areas within the township to accommodate emergency, medical, treatment, correctional, or similar institutional uses having a special character.
Is the term similar institutional uses defined anywhere in the township zoning ordinance?
Not to know where.
What land use describes Eagleville Hospital?
I couldn't say exactly what it was approved as. Again, it approved it. I believe Eagleville Hospital existed prior to zoning in the township, and I couldn't speak to its approvals in the past.
Do you know offhand, or perhaps you could look at the zoning ordinance, is the term hospital defined in the township zoning ordinance?
I can look for you.
Sorry?
Let me look. It is.
It is?
Yes, sir.
And where is it found?
I'm sorry, the definition?
Hospital, yes.
And, I'm sorry,
Where's the definition of hospital found?
it's in the definition section of the ordinance, 143-6.2.
Read the definition for us, please.
A use that involves the diagnosis, treatment, or other medical care of humans that includes case requiring stays overnight and that may include outpatient care. A medical care use that does not involve stays overnight shall be considered a medical office or clinic. A hospital may involve care and rehabilitation for medical, dental, or mental health, but should not include housing of the criminally insane, nor primarily involve housing or treatment of persons actively seeking an official sentence after being convicted of a felony. A hospital may also involve medical research and training for healthcare professionals.
What page are you on, Mr. Rosinski?
Mine is 143-52.
Give us,
Mike, you're actually reading from 143-6.2, correct?
That's right, letter N as in Nancy.
So the township really has two different sections relating to definitions, correct? One is 143-6, and then there's a subsequent section, 143-6.2, the title of which is Use Definitions and Regulations, correct?
My understanding in the composition of the ordinance was that 143-6 is a more general terminologies, or the definitions of more general terminologies, and 6.2 is a little bit more direct.
So the answer though is yes, there are two separate definitional sections in the township zoning ordinance.
I don't have an opinion on that.
Well, let's break it down. Section 143-6, what's the title of that section in the zoning ordinance? Maybe just go to the table of contents.
Definitions.
And then there's a 143-6.1. What's the title of that in the table of contents?
Applicability of use definitions. Use definitions.
And then there's a section from which you were just reading, 143-6.2, and that's use definitions and regulations, correct?
That's correct.
So the term hospital is defined in 143-6.2, but not 143-6, is that correct?
Let me check 6. No, it does not appear there.
It does not, correct?
Correct.
So let's go back to the INO district. That's Article 27, correct?
Yes, that's correct.
Those are the regulations that govern Eagleville Hospital, correct?
I would not go that far in that the definitions, that the hospital existed prior to the drafting of the ordinance.
Today, would those regulations apply to Eagleville Hospital, or they don't?
I can't speak to their current operation.
If Eagleville Hospital wanted to add a building or change the use of an existing building today, would it be governed by the INO district?
Yes.
And the Eagleville Hospital can't do whatever it wants, can it?
No, it cannot.
The use regulations of the INO district are 143-207, correct?
That is the list of permitted uses.
Read for us section 143-207B.
Community center, adult education center, senior citizens center, or similar facility operated by an education, philanthropic, or religious institution subject to the following. The use should not be conducted as a private or profit business. No outdoor recreation area should be located closer than 50 feet to any lot line.
If we go to the first two lines in 143-207B, you see the term or similar facility?
Yes, I do.
Is that term, similar facility, defined anywhere in the Lower Providence Township zoning ordinance?
Not that I'm aware of.
Is philanthropic, that appears in 143-207B, is that defined in the township zoning ordinance?
I don't believe so.
Do you recall the draft ordinance that was before the Board of Supervisors on April 4th, 2024?
I am somewhat familiar with it.
Did that propose a definition of philanthropic?
I don't know.
So back to the INO's district in section 143, we talked about permitted uses. 143-208 provides for conditional use, correct?
Yes,
And a conditional use is a form of permitted use, correct?
it is.
And then section 143-209 lists special exceptions uses, correct?
Yes, sir.
Do you know whether RHD is for-profit or non-profit?
I believe they are not-for-profit.
They are not-for-profit.
That's true. That's what they've attested to. Attested to.
Mr. Jonas, we're going to take a break in the next 10 minutes. So if you know a spot that's a good spot to break, just let us know, okay?
I somehow sensed that you knew this was a good time, Mr. Fry.
Is it? Okay. I saw you looking, so I wanted to take the opportunity. All right, we're going to take 10 minutes? A 10-minute break so people can use the bathroom or anything to just stretch their legs. We'll come back on the record.
It's off to the left. This is a concert.
Nairobi,
We're going to start back up in 1 minute. Okay, the board's back in session, and I think I'll turn it over.
Thank you, Mr. Fry. Can we make part of the board's record the two subpoenas that we had submitted to the zoning board? Can you add that to your list of exhibits?
So just want to identify it for us. Two letters, is that what you're asking for?
The subpoenas themselves.
Oh, the subpoenas, sure. So A2 will be the subpoena request.
Is this going to be ours or the board exhibit? It doesn't matter, but.
I'll make them a board exhibit, so where was that?
Mr. Fry, I would offer if we're going to start marking exhibits, we should start with the subpoena that was issued for Mr. Rosinski as well, so the record's complete.
So we'll go B6 will be the subpoena for Michael Merzinski. B7 will be the subpoena for E.J. Mentry. B8 will be the subpoena for Michael Clark.
That's it. Thank you.
So just for the record, the one for Michael obviously was already signed, that's why he's here. The one for E.J. Mentry was signed this evening. I will distribute that to everybody tomorrow. And the one for Michael Clark has not been signed yet. We're taking that one under advisement.
Thank you. We have an exhibit we pre-marked as A2 that we'd like to distribute, give to Mr. Masinski, the zoning hearing board and council.
I'm going to object to this prior to the board taking review of this.
The objection's a little premature, don't you think?
I don't know, it's just handed to the board. I think I have to object now before they review it if I have an objection to the document.
So this was A2.
Two.
It's a municipal service agreement. And what is your objection?
The objection is that this is not relevant to these proceedings. It's a document that's from outside and related to a separate negotiation. It is not part of the determination or the validity challenge that is before the board.
Actually, it is, and the board, it seems to me, should be identified. The witness can answer whether he's ever seen it before, and then if it's an offer, it'd be the appropriate time then for objections, but I think we have the right to have it marked and ask the witness if he's ever seen that before, and we would suggest to you that this is another reason for Mr. Clark to appear. This is a document that the township solicitor drafted in connection with the ordinance that was considered on April 4th, 2024. It's all part of the picture of the validity challenge. It's all part of the issue that's now also in federal court.
Mr. Clark and the federal case are not part of what we're doing right now. Mr. Brzezinski's on the stand.
I understand. I think we're going to allow it to be marked and introduced and have questions started.
Thank you, Mr. Pryor. Ms. Masinski, you have that document?
I do.
What's the title of it?
Municipal Services Agreement?
Have you ever seen that before?
I don't believe so, no.
You have another document, which is marked A3. Mike, have you ever seen A3 before?
Yes, I have.
Is this the ordinance that was considered by the Board of Supervisors on April 4th, 2024?
I don't recall exactly.
Let's assume that it is. If you turn to page 3 to section 1, propose a definition of philanthropic.
Yes, sir.
I'm sorry?
Yes. Sorry.
But as you look through the various pages, does it refresh your recollection whether you've seen this before?
I believe I've seen it. I just don't recall in the context of the April 4th meeting.
You did not draft this, correct?
No, sir.
To your knowledge, was this ordinance ever enacted?
To my knowledge, no, it has not been added.
Mike, is RHD supportive housing use permitted as a by right use in the INO district?
No, sir.
Why not?
I can't speak to that.
It's not permitted, but you can't explain why.
Correct.
Is it permitted as a conditional use?
No,
Why not?
I can't speak to that.
Is it permitted as a special exception?
Not explicitly, no.
Special exception has to be explicitly described, is that correct?
there are provisions for consideration of special exceptions if it is a use that is similar to other explicit uses
And where does that appear?
in various districts.
Does it appear in the INO district?
No, sir.
But if we go back to 143-207B, there are certain uses, specifically quote, community center, adult education center, senior citizen center, or similar facility operated by an educational, philanthropic, or religious institution. Those are permitted uses, correct?
Yes, sir.
You know the ages of the persons who were proposed to reside in the supportive housing facility at Eagleville Hospital?
As I recall, it's 18 or above. As I recall, it was 18 years of age or above.
You know anything else about the qualifications of someone to reside in that proposed supportive housing facility?
I believe that there were certain conditions, but I couldn't speak to them specifically.
Let's go back to that section you were describing before, 143-6.2. And particularly subsection O.
Under what category, sir?
Under institutional uses.
Yes, sir.
In a general sense, would you consider the supportive housing facility to be an institutional use?
In a general sense, yes.
Read the definition of institutional group living quarters in section 143-6.2 under institutional use.
Residential living quarters where the residents do not live together as a single housekeeping unit. To be considered a single housekeeping unit, all residents must have common use of and access to all living areas, eating areas, bathrooms, and food preparation and serving areas. Dormitories, barracks, prisons, nursing homes, personal care homes, life care facilities for the aged, long-term care areas of hospitals, shelters, wards, juvenile institutions, group homes that meet the above definition, monasteries, convents, and other similar living quarters that meet the above definition shall be considered an institutional group living quarter.
So that phrase and that definition you just read includes the words similar living quarters, correct? The next to the last line of O.
Other similar living quarters. Yes.
The last clause in O reads, and any other similar living quarters that meet the above definition shall be considered an institutional group living quarter, correct?
That's what it says.
if we go back a page, the term institutional use is defined, is it not? In section 143-6.2?
Yes, it is.
Read that, please.
An organization having an educational, social, philanthropic, or religious purpose, such as a hospital, hospice, care facilities for the aged, nursing home, life care center, assisted living care, church, reformatory, school, college, and university. And then the following are specific types.
Let's jump back to the first definition section 143-6, and tell the zoning board if the term institutional district appears in 143-6.
It's not defined, it is mentioned and says includes the INO zoning district.
Let's go back to the 143-6.2 under the institutional uses, and again, O, institutional group living quarters. Let me know when you're there.
Okay.
Can you tell me and the board where in Lower Providence Township, in what zoning district, and institutional group living quarters is expressly permitted?
I could not tell you a specific zoning district in which it is stated as specifically as an institutional group living quarter.
So just to paraphrase, so we go from the beginning to the end of the zoning ordinance, we will not find institutional group living quarters as a use permitted by right, conditional use, or special exception in any Lower Providence zoning district. Is that correct?
I wouldn't go to that point, no, sir.
All right, tell me where it appears.
It is perhaps similar to uses that are explicitly permitted and therefore could be approved as a special exception.
And what zoning district would that be?
Depending on the class of the property, it could be permitted in the HC zoning district.
In the HC district?
That's correct, sir.
But is it expressly listed as a permitted use by right, conditional, or special exception with those words, institutional group living quarters, anywhere in the zoning ordinance?
Not with those words.
Do you know why that term is there then?
No, sir.
Is the supportive housing use, in your opinion, is that an institutional group living quarter?
Yes.
Mike, the Lower Providence Township zoning ordinance provides for various types of housing, is that correct?
Yes, sir.
And types of residential uses in various zoning districts, correct?
Yes, sir.
Based on your experience as the Township Code Enforcement Officer and Zoning Officer, is housing an important land use?
Objection? What are we defining as important?
If you were writing a zoning ordinance, Mike, would you make sure that zoning ordinance included residential and housing uses?
Yes, sir.
Would you provide housing through writing an ordinance for the young?
I would imagine so, but this is pretty abstract type of question.
Do you think it's important for a township to provide housing for young people?
Yes.
How about for older people?
Yes.
How about for those who are disabled or infirm?
Yes.
How about for people who are homeless?
Yes.
Have you ever heard of the Lower Providence Township Human Relations Ordinance?
Yes.
What is that ordinance?
I'm going to object that human relations ordinance is not in the jurisdiction of the zoning hearing board to interpret or to rule on in any way. It is not a zoning provision. It is as it says, a human relations provision. This board is specifically limited to provisions within the township's established zoning ordinance pursuant to the MPC and its processes.
While we agree with that statement, I think it is relevant to hear his testimony to see if it would play in this argument.
I'm sorry?
I think it's relevant to hear this line of questioning to see how it would apply in this situation.
I'm sorry, but if it's not a zoning provision, if it's not a zoning ordinance, it should have no place in a zoning proceeding. Just because the applicant has raised it does not mean it's appropriately before the board, nor does the board have jurisdiction over anything involving the human relations ordinance.
I don't know if that's that question. I think it's relevant to hear his opinion as it relates to this code and how it would influence the zoning ordinance. So we're going to overrule the objection, and if it goes too far, then please raise the objection again. But right now, I think it's relevant to what we're listening to.
Mr. Fry, if it's at all possible that people can't exhibit manners and civility, may I ask the board to consider asking them to be ejected from the hearing hall?
Okay, folks, just please be respectful of everybody. Keep your language civil, okay? And we'll listen to the testimony here. Thank you.
What are we up to, Mr. Jonas?
What's that?
8-4.
8-4, yes, thank you, Mr. President. Mike, would you read section 17.2 from A4, which is a one-page from Chapter 17, Human Relations Commission, adopted by the Board of Supervisors of Lower Providence Township, November 17th, 2022, by ordinance 674. Read for us section 17-2, point capital A. A, sorry, A.
Lower Providence Township finds that it is of high public importance to adopt appropriate legislation to ensure that all persons, regardless of actual or perceived race, color, religious, creed, ancestry, sex, national origin, age, except in public accommodations, veteran status, handicap, use of guide or support animals because of blindness, deafness, or physical handicap of the user, or the user is a handler or trainer of support or guide animals, or sexual orientation, gender identity, or gender expression enjoy the full benefits of citizenship and are afforded equal opportunities for employment, housing, and public accommodation.
So let's emphasize two excerpts from that. The first line, Lower Providence Township finds that it is of high public importance, correct?
It says that, yes.
To adopt appropriate legislation. It says that, correct?
It does.
Is the zoning ordinance legislation?
It is.
And at the very end, does it mention one of these high public important factors to be housing on the very last line.
Yes.
Is the proposed supportive housing, is that a form of housing in your opinion?
I'm sorry, I misunderstood the question.
Is supportive housing a form of housing?
Yes.
Now, you mentioned that RHD had previously sought a location on Trooper Road, correct?
Yes.
And that was a former Harley-Davidson dealership?
Yes.
The address is 1217 South Trooper Road?
I believe that's correct.
We're going to mark A5. Mike, this is your letter dated May 31, 2022, correct?
Yes, sir.
And this was a request for a zoning opinion relating to the 1217 South Trooper Road property, correct?
Yes, sir.
Did you draft this?
I did.
Did you confer with anybody before you signed and sent this?
I don't recall.
Now, the first paragraph, well, you conclude in this that the supportive short-term housing was not permitted at 1217 South Trooper Road, correct?
Yes, I did.
And you noted in your letter that 1217 South Trooper Road is Zone HC, Highway Commercial, correct?
Yes, sir.
Is that the same HC zoning district you mentioned a few minutes ago?
It is.
And did you also acknowledge in the last sentence of first paragraph, that RHD is a non-profit organization, correct?
Yes, sir.
Read the second paragraph of your letter.
Supportive short-term housing is not a specifically defined use within the township's zoning ordinance. However, the proposed use is clearly included within the institutional group living quarter, which is defined in the zoning ordinance as provided within institutionally zoned properties under 143-6.20. While the applicant is a nonprofit organization, that does not mean that the proposed use constitutes a philanthropic use. Rather, the use is very clearly institutional group living quarters, which is not permitted in the HC district.
All right, so let's dig into this a little bit. You said in that letter, this does not mean that the proposed use constitutes a philanthropic use. At that time and now, the township zoning ordinance did not have a definition of philanthropic, did it? Or does it?
That's correct.
And your last sentence of the second paragraph, again, read that.
Rather, the use is very clearly institutional group living quarters, which is not a permitted use in the HC district.
And read, I'm going back a little bit, read the second sentence of the second paragraph.
However, the proposed use is clearly included within the institutional group living quarter, which is defined in the zoning ordinance as provided within institutionally zoned properties under 143-6.2-0.
Doesn't this mean then, if there were an institutionally zoned properties, that and institutional group living quarters would be permitted there? Isn't that what you say in this letter?
No, it does not.
Your second sentence says, the proposed use is clearly included within institutional group living quarter, which is defined in the zoning ordinance as provided within institutionally zoned properties under 143-6.2.0.
Yes.
Why does that not mean that this is a permitted use in an institutionally zoned property?
Because the definitions in 140, in our zoning ordinance are not by district. They are divided up by categories, just as if commercial uses, we have something like 45 commercial uses. That does not mean it's necessarily permitted in any given zoning district. And so that would be the case here.
Doesn't your fourth line say provided within institutionally zoned properties? Isn't that the language in your letter? Isn't that what your letter said?
It is under that category of the definitions. There is, as you referred to earlier, sir, there are several definitions that are listed under institutional, just like there are several definitions under commercial, residential, so on and so forth. The institutional group living quarter definition falls into that category, but I was not opining as to a particular district.
In May of 2022, how many institutional zoning districts did Lower Providence have?
I couldn't speak to that.
What about today? Let's go through the zoning ordinance table of contents. How many institutional zoning districts are there in Chapter 143 of the Lower Providence Township Code?
The institutional overlay is an overlay, and it lies over several portions of the township.
Is there any other zoning district that is institutional other than the institutional overlay district?
No, sir.
Is the Eagleville Hospital located in the institutional overlay district?
It is the institutional overlay of the R1.
And R1, correct?
I'm sorry?
The underlying zoning is R1, and on top of that is layered the institutional overlay district for Eagleville Hospital, correct?
Yes, sir.
Looking at this letter, what was the basis of your conclusion that RHD, although nonprofit, was not philanthropic if the zoning ordinance did not have a definition of philanthropic?
I don't recall in that this was 2.5 years ago when this was drafted. I would suggest, though, that there are probably examples in which nonprofits are not philanthropic. They're not exactly synonymous terms.
What's the definition of philanthropic? If it's not in the ordinance, what's your definition?
My definition would be of a emphasis on a charitable use.
You don't think provide housing for homeless is charitable?
That's not my question, or I'm sorry, that's not what my determination was based on.
Do you think this is a reasonable definition of philanthropic? Philanthropic shall be construed to a business structure in which funds are used for humanitarian, charitable, or similar purposes?
I would want to consider that more thoroughly to give a definitive answer on that right now.
Do you think that a use that takes people who are living on the street in freezing weather and gives them a residence with walls and a ceiling and bathrooms and food, do you think that's humanitarian?
At the cost of who?
With,
In your mind, but not to the people who are in the audience.
I am charged with the literal interpretation of the ordinance, not what I personally would wish or not wish. So it's really, in my opinion, it sounds reasonable.
It sounds reasonable, it sounds, what do you mean reasonable?
That it would be, that providing for homeless would be a charitable use.
So is it your opinion today that it would be considered, given that the ordinance doesn't have a definition, you would consider that to be philanthropic, what RHD is proposing?
Yes, I guess it would be.
Did you receive the zoning permit application for supportive housing by RHD on the grounds of Eagleville Hospital?
I did.
Mike, I'm showing you A6. This is, well, let me back up. You received a zoning permit application and you denied it, correct?
That's correct.
And then you issued this letter dated October 6, 2023, correct?
That's correct.
Did you draft this letter?
Yes, sir.
Did you confer with anybody before you drafted this letter?
I don't recall.
Read the letter.
Dear Mr. Camuso, the Township Community Development Department has recently received a zoning permit application for a change of use for the Eagleville Hospital property at 100 Eagleville Road. As I understand it, the proposal is to establish supportive short-term housing as a new use with the existing hospital. The introduction of a second primary use is not permitted under zoning ordinance 143-13, and the proposal will require zoning relief. Supportive short-term housing is not a specifically defined use within the township zoning ordinance. The use may be qualified as an example of institutional group living quarters, the definition of which is provided under institutional uses, but are not explicitly permitted within the INO institutional overlay, Article 26. Nor is supportive short-term housing explicitly permitted in the underlying R1 residential district, Article 5. This application cannot be approved and is hereby denied. Should you have any questions or concerns, please feel free to contact me.
So let's take this in pieces. Taking just by itself the use of supportive housing and ignoring any other zoning regulation, okay? I just want you to focus on the use of supportive housing. You understand that to be. If we put aside any other zoning regulations, is supportive housing permitted in the INO district at Eagleville Hospital?
It is not explicitly permitted.
Is it prohibited?
It's not explicitly prohibited.
You said the proposal will require zoning relief at the end of your first paragraph, correct?
Yes, sir.
What zoning relief would it require? In order, if I want to put supportive housing at Eagleville Hospital within its walls and security, what zoning relief do I need?
Well, it could be any number of things in terms of zoning relief. In terms of the use, the issue of that last sentence is that it is introducing a second primary use because the hospital is already there and is already the primary use on that property.
So the use is permitted except there's an existing use already on the ground, is that correct?
I'm not, no, I'm not saying that.
I thought you just did say that.
No, sir, my issue was with as a second primary use.
So, but for that regulation, if you did not have the provision in the Lower Providence ordinance that limits a property to one principal use, if Eagleville Hospital were vacant today, no buildings, no uses, putting aside setbacks, impervious coverage and all, could I put a supportive housing use at Eagleville Hospital property?
It would require interpretation. The second paragraph speaks to the need for, because supportive short-term housing is not a specifically defined use within the ordinance, the use may be qualified under that broader group of institutional group living quarters, and the definition would need interpretation by the zoning hearing board.
Isn't it your job to provide interpretations?
No, sir.
You never interpret the zoning ordinance.
Sir, as discussed previously, my job is to follow the ordinance as literally as I can. And therefore, if there are questions in which I cannot comfortably answer, then I require the applicant to go to the zoning hearing board so that a particular situation can be discussed in greater detail than what I might have on a two-page application.
So today, you're saying to the zoning board that you can't determine if supportive housing, which you said qualifies as an institutional living quarters, you can't render an opinion as to whether that use all by itself on a vacant property is permitted at a property zone INO. Is that what you're telling the zoning board? You can't make that interpretation?
Yes, sir.
Let's take a look at that last sentence in the first paragraph. The introduction of the second primary use. You see that?
I do.
You're relying upon the ordinance section 162-13, correct?
143.
143-13?
Yes, sir.
Read that to the zoning board, please.
one principal use maximum. A maximum of one principal use is permitted on each lot except as permitted within a shopping center. If conditional use approval is granted for two or more principal uses in the R, PBD, HC, GC, or BC zoning districts, or the EDC zoning district, if specifically stated as permitted by a provision of this chapter.
Have you ever heard the phrase in the zoning ordinance, any one of the following uses? Any one of the following uses?
I believe so.
What does that mean to you, at least in no context? What does that phrase mean to you?
That if a use was part of a explicitly stated list.
Could you try that again? What's the answer? Sorry.
My understanding of the term would be that it would need to be part of an explicitly stated list.
If the phrase is any one of the following uses, can I have two principal uses in that zoning district?
Not unless other relief was granted or other approvals were granted.
Does the phrase any one of the following uses appear in the Lower Providence Township zoning ordinance?
I couldn't speak to that.
Take a look at R1.
I don't have the R1.
Can you borrow that from your solicitor?
You're asking a question or you have available.
And we can get taken like that, or we can be collaborative and give them the ordinance.
That is part of that to be right now, Mr. Jones. That's inappropriate.
Do you have the R1 district?
I do.
I'm going to direct your attention to the first sentence in section 143-32. Read it.
First sentence is, a building or group of buildings may be erected or used, and a lot may be used or occupied for any one of the following uses and no other.
So that phrase is right there, any one of the following uses, correct?
Yes.
Let's go to R2, section 143-35B. Read the first sentence.
A building or group of buildings may be erected or used, and a lot may be used or occupied for any one of the following uses and no other.
Let's go to R3, section 143-48.
A building or group of buildings may be erected or used, and a lot may be used or occupied for any one of the following uses and no other.
Let's go to R5, section 143-56, first sentence.
A building or group of buildings may be erected or used, and a lot may be used or occupied for any one of the following uses and no other.
Now let's go to the general commercial district, section 143-91. Read the first sentence.
Lot with a minimum area of 20,000 square feet and a minimum width at the building line of 100 feet, any one of the following uses and no other is permitted.
Let's go to 143-93, class 2 permitted uses in the general commercial district.
On lots with a minimum area of 40,000 square feet and a minimum width at the building line of 200 feet, any one of the following uses and no other is permitted.
Let's go to 143-95, class 3 permitted uses, the first sentence.
On lots with a minimum area of 2 acres and a minimum width at the building line of 300 feet, any one of the following uses and no other is permitted.
Now, by contrast, let's go to 143-97, class 4 permitted uses. In that introductory sentence, do you see the same language, any one of the following uses?
I'm sorry, you said class 4?
Class 4, 14397, the introductory sentence.
On lots with a minimum area of 5 acres and a minimum width at the building line of 350 feet, the following uses are permitted.
So it doesn't repeat any one of the following uses, does it?
I'm sorry, can you ask the question?
Say, instead of saying any one of the following uses, 14397 says the following uses are permitted, correct?
Yes.
Let's go to the INO district. Specifically, section 143-207. Let me know when you're there.
I'm there.
Does the introductory sentence say any one of the following uses?
It says the following uses shall be permitted.
Your answer, it does not say that, correct? It does not say any one of the following uses, correct?
That's correct.
And for, still in the INO, section 143-208, conditional uses, the introductory sentence says the following conditional uses are permitted, correct?
Yes.
And it doesn't say any one of the following uses, does it?
No, sir.
I have no further questions of the witness. Thank you, Mike.
Mr. Fry, since the hour is clearly getting late and people are getting tired, I would ask if we can maybe adjourn at this point and resume tomorrow.
Where you were going with this, it is 9:38, it's a natural spot for adjourn for this evening, and we can pick it up with cross-examination from the township, then Streamlight, then Mr. Yanoff for his clients, and then the individual clients will go, and then we'll go back to presenting and redirect at that point in time. We'll pick up in that order tomorrow evening, 7 o'clock in this room, and just for the